Awesome. If folks are watching and want to share what you're having for lunch, if you're eating lunch right now, you can go ahead and drop that into the chat. I'd love to hear maybe some inspiration as I will get lunch after this, but we'll go ahead and get started. I'm just going to share my screen briefly to welcome folks here. So glad that you're able to join for our second Ask an Attorney lunch session. My name is Mica. I am the Community Strategy Lead at the Legal Rights Center. And our mission is to work with our communities to seek justice and promote racial equity for those to whom it has been historically denied. So we do this work through criminal defense, restorative justice, advocacy, and community education. And that's why we're here today. A good part of our work that's kind of taken over our lives in the last few weeks since the beginning of the Chauvin trial has been supporting community through the trial, through community education. So the creation of educational resources, as well as events like this, where folks can get their questions answered about how a criminal trial works. We also have on our website a restoring processing toolkit, and we've been working with educators and youth workers in our communities to help them as they support young people in processing the trial themselves. And then we're also continuing to provide legal support to folks who are out exercising their rights to protest and gathering in community during the trial itself, in partnership with the National Lawyers Guild and the Twin Cities Legal Support Hotline. So I'll drop our website into the chat in just a second for folks to keep up to date with the information that we're creating and the resources we're putting out there. But y'all came here to get some questions answered and to hear some expert legal minds analyze the 2.5 weeks that we've seen of the trial and to look ahead to what's coming. So if this is your first time joining, the way that we structure these Ask an Attorney sessions is really kind of in chunks because we know that there are a ton of questions out there, but we want to make sure that we cover topics that we've heard from community that are important. So we're going to do just a quick little recap of where we've been for the last 2.5 weeks now that we have a fully seated jury in the Chauvin trial. We're going to spend a good chunk of time talking about what's to come next, what are the different parts of a criminal trial, and are happy to answer questions that you all have related to what we'll see in the next few weeks. And we'll preview a little bit of what we anticipate to be the cases made by the state and by the defense during the trial. And we'll make sure that we leave open time towards the end for other questions that maybe don't fall neatly into those categories or questions that have come up as you've been listening. So you're always welcome to use the chat function here in Zoom. You can chat our panelists' questions, and also you can use the Q&A function and type your question out there. So with that, I'm going to introduce the team of our brain trusts here who's going to be supporting us getting our questions answered today. I'd like to invite them to introduce themselves a little bit. So Mica, would you get started first and then pass it over to Josh and then Nick?
Yeah, hi everyone. I'm so glad we could all be here in this space. My name is Mica Standing Soldier. I am one of the law clerks that will be working with the Legal Rights Center this spring and summer in regards to the trial. Today I'm going to be kind of moderating, so I will be, sort of translating the questions to Josh and Nick to answer. Yeah, and I'm really excited to be here. I'm gonna pass it off to Josh.
Thanks, Mica. Hi, everyone. My name is Josh Esmay. I'm one of the attorneys on the adult team here at Legal Rights Center, where my work focuses on defending people charged in criminal court and also helping people overcome the collateral consequences of having that happen, which means the sort of long-term impact of having a record and having that impact your ability to find housing, employment, and that type of thing.
Hi, everybody. My name is Nick Pouladian. I'm also an attorney with the Community Defense Program. I work representing adults who are charged in criminal court, and very happy everyone is here and very happy and privileged to be here with Mica and Josh and Mica. So thanks for tuning in.
So I guess agenda item number 1 was sort of a quick recap. And then we'll jump in. Nick is going to kind of walk us through what to expect in terms of the different steps and phases of the trial. And then I'm going to walk us through what we kind of anticipate some of the arguments that each side will make. And then we're going to open it up to questions. So I don't know, in terms of a quick recap, we got a jury seated. I think it happened maybe even a little bit more efficiently than they thought it was going to, because they had sort of planned through the end of this week to be continuing on with voir dire. Sort of all the parties knew that they weren't going to start with any arguments until next Monday. So I guess they gave themselves plenty of time there. They did pick the jury. We saw some interesting things happen. We saw two jurors who had been seated were later struck for cause after finding out about the civil settlement that the city entered into with George Floyd's family, and then telling the judge that would undermine their ability to be impartial. So that was kind of interesting. We talked a fair amount on our session 2 weeks ago about all of the drama around the Court of Appeals last minute decision and how that impacted the third-degree murder charge. But sort of the long and short of it is that the third-degree murder charge was reinstated, and that will be going to the jury for them to decide guilt or innocence on that charge, as well as the second-degree murder charge. If you're more interested in that, I would suggest just checking out our recording from this session a couple weeks ago. Nick, are there any other big highlights, or Micah, are there any other big highlights you think I missed?
I think you nailed it. The third-degree murder charge and the jury selection process. We did also see some motions in limine, those pretrial motions, so talking about some pieces of evidence that can or can't come in. But Josh, I think you hit all the big major points.
All right. Well, Nick, do you want to start walking us through what to expect as the trial proper starts?
Yeah, that sounds great.
Guys, could you allow me to screen share, and then I'll man the PowerPoint again?
And Josh, I apologize in advance if I go too fast or too slow and mess up the slide order, but I'll do my best.
Yeah, just tell me where you want to be.
Sounds good. Well, I think we can go ahead right there. Yeah, we'll just start right there.
Let's see, where is the present button? There we go.
Perfect, thanks. So just like Josh sort of summarized and recapped, we've gone through jury selection. We now have a jury who is seated in the case. So while jury selection and those motions in limine are part of the trial process, we're really getting to what we traditionally and typically think of as the trial proper now. So on this slide, I've sort of put the bullet points of the major topics that will be happening that we'll talk about briefly, beginning with opening statements. So we can go ahead and jump to the next slide, please. So opening statements are really sort of the kickoff of the trial. That's what we think of when we think of a trial, and a lot of times what we've seen on TVs or in the movies. The opening statement is the first time this jury that's been seated is going to hear from the attorneys themselves, and not asking questions about, can you be fair and impartial? The attorneys are going to be talking to the jury about what they expect the evidence in the case will be and what it will show. And that is going to come from the perspective of each respective party. So the state is going to get up there, whichever attorney is going to do that, and they will tell the jury, essentially, here's a roadmap or here's a preview of what the evidence is going to show. Here's who you're going to hear from. Here's what they're going to say, and here's what it's going to mean, right? Sort of a nuance is that it's not a closing argument, it's an opening statement. So it's not a time for the attorneys to get up there and say, Derek Chauvin is guilty or Derek Chauvin is not guilty and you can't believe this person and don't trust that. That's not the time for that portion of the trial. The opening statement
is on TV all the time.
Exactly. So, really it's just saying, folks, here's what you're going to see. Here's what you're going to hear. And at the end of the trial, we'll come back up here. And, if you're the state, you're saying, we are going to ask you to find Derek Chauvin guilty because that's what the evidence will show. And the defense is going to get up there and say, the state is going to fail to meet their burden of proof, that proof beyond a reasonable doubt. And the evidence is not going to meet what they need to. So at the end of the trial, I'll stand up here and I'll ask you to find Derek Chauvin not guilty. So that's kind of a brief preview of opening statements. They might be long, they might be short, depending on sort of how detailed the parties want to get. But that's their first major exposure to the jury. And after that, the case in chief and the presentation of evidence begins. The opening statements are not evidence. Really nothing the attorneys themselves say are evidence. What is evidence is when you have the witnesses come in and testify. So you can have a live human witness testifying about what they saw, what they heard. Other forms include videos. There are going to be lots of body camera videos, obviously that cell phone video, photographs, expert medical reports, and other documents. Because the state has the burden of proof, they will go first. So they'll put on their quote unquote case in chief, and that just means they're putting on their case. So they'll call witnesses and ask them to testify about what they saw and what they heard. Josh will sort of get into the strategy afterwards, kind of about what we can expect, but there will be law enforcement called, there will be bystander witnesses, medical experts, use of force experts, all responding to the questions that the state's attorneys are asking. So that's really where the questioning begins, and the answers that they give are the evidence, and that is what the jury is going to have to work with when they go back in the room. And the judge is the referee who sort of decides what evidence is or isn't allowed. Some of that has already been taken care of in the motions in limine aspect. So you can't just necessarily call anybody to talk about anything or everything. It needs to be relevant to the case, and it needs to be okay with the judge essentially permitted to come in. So next slide, please. Thanks. So after the state goes through all of their witnesses, after they've put in all of their evidence, whether it's video recordings, medical reports, human testimony, once they've finished with everything, they rest. And resting just means that they're done. They don't have any other evidence to put into place or anything else that they're going to be offering at that time. So you'll see that a lot in movies or TV. The state will get up there and they'll say, Your Honor, the state rests. That means their case is done. After that, it goes to the other side, the defense, and they'll have the opportunity to choose to put on a case or not put on a case. Something important to remember is that the defense has no obligation to put on a case. They don't have to do anything to prove or disprove anything. All of that burden is put on the state, and it sort of depends on a case-by-case basis whether or not a defendant will put on a case. In this case, they absolutely will be putting on evidence themselves. So this is a big jumbled word slide, but a motion for directed verdict of acquittal, also called a halftime motion, is a motion that the defense can bring after the state has rested, after the state puts on their case. And what that is essentially the defense saying, Judge, looking at all of the evidence the state has put in, even if you accept that as true, and if you look at it in the light most favorable to the state, meaning if you believe everything they've said, and if you give every possible inference in the state's favor, there's still not enough here to convict. It's insufficient to maintain a conviction. A juror would have to have reasonable doubt. A really hyperbolic example could be if somebody is charged with drugs and the state calls a bunch of witnesses and says, well, cocaine is a drug and the drug is illegal. But if there's no testimony showing that the defendant possessed drugs or had drugs on them or had that type of drug, even if everything the state said is true, that's not enough to convict that person of possessing cocaine. So that's an extreme example. It's usually not that clear cut. But in this case, the defense could, after the state puts on its evidence, say, Judge, we would ask you to dismiss one or all of the charges because there's simply not enough evidence here to support a conviction. That likely won't be granted. It really is on a case-by-case basis, but it would be shocking, I think, if Judge Cahill granted that motion if it were made during this trial.
Nick, it's right. Would you agree that the parties may make that motion even if nothing else, just to preserve the record for appeal and that kind of thing, right?
Absolutely. Really good point, Josh. Yep. So for that motion or any other motion, even if the defense thinks it might not be a winning motion, just like Josh said, they'll still make it to preserve it for appeal, meaning if there's an argument to be had at the Court of Appeals, you have to generally make it at the district court level. Otherwise, you've given that up and you can't argue it down the road. Really good point, Josh. Thanks. So closing arguments. After, let's say the motion for directed verdict is made and it doesn't go through. Then it's the defense's turn to put on their own case if they want to. And in this case, they certainly will be doing that. And it will look very similar to what the state does. It's just the other party doing it. So the defense will be calling their own witnesses. They'll have their own experts. They may be showing some of the same or some of their own video, photographs, medical reports, things like that. One important thing to remember, and we'll sort of have to see, is a defendant never has to testify on their own behalf. The Fifth Amendment says that you have the right against self-incrimination. That means you don't have to testify. You have the right to remain silent in court. And nobody can comment on that. So if Derek Chauvin chooses not to testify, the state can't get up in front of the jury and say, folks, Derek Chauvin didn't choose to come up here and explain what happened. They can't do that. They can't talk about that. I think, in my opinion, I think it'll be likely Derek Chauvin will testify, but he doesn't have to. And if he doesn't, they certainly can't comment on that. So after all of the states and the defense put on their cases, then you get into closing arguments, and that's sort of really what you see in those like movie or television moments. That's when the attorneys have all of the evidence that's going to be in the case. They've finished putting in evidence, and they're going to get up there and they're going to argue about what that evidence means and what the jury should take away from that. They're going to argue that their witnesses are more credible, have presented more credible evidence, that their version of the story makes more sense, and that the jury should believe what they've seen from the state, or they should believe what they've seen from the defense and disbelieve the other side. And after that, then the case will officially be done. That is the end of kind of the trial proper. And at that point, then it goes back to the jury, and for the jury to decide what they're going to do with the evidence. And that process is called jury deliberations. Deliberation means considering the evidence. So the jury can only consider the evidence that's been submitted at trial. And we've seen a lot of emphasis on that throughout the jury selection process of saying, you know, whatever you've read or heard or talked about, you have to put that out of your mind. And you have to only use what's been shown to you at trial. Any verdict, whether it's guilty or not guilty, needs to be unanimous. And they have to provide a verdict for each charge. So in this case, there are 3 charges. The jury will come back, presumably, with 3 verdicts, either guilty or not guilty for each respective verdict. If the jury can't agree, if they can't come to a decision on any or all of the charges, that's going to be called a hung jury. A hung jury just means that the trial hasn't been able to be completed successfully. And part of that is a jury coming up with a decision of guilty or not guilty. So if there is a mistrial, essentially it'd be up to the state to choose to retry it or not retry it. And we would see the process kind of run through all over again. So the guilty or not guilty is what's called the verdict. That's just where the jury decides, did the state meet its burden of proof of beyond a reasonable doubt for each or any of the charges. And after the verdict, if the jury comes back with a conviction, with a guilty finding for any or all of the charges, the next step is sentencing. The jury is the one who decides whether someone is guilty or not guilty. They are the finders of fact. The judge is the person who decides and imposes the sentence. Now, the judge doesn't have free rein to impose whatever sentence they want either. There is a statutory maximum for each crime. And in Minnesota, we also use what's called the sentencing guidelines. And I think Josh has talked about that before, but that's essentially a box, a range of, depending on the severity level of the charge and depending on a person's criminal history score, there is a little box on a grid that tells you what is the presumptive amount of prison that this person will be getting, or will they be getting probation? And that is what the judge will be working with. Now, the judge can go above or below that presumptive number. And the judge could also send somebody to prison instead of giving them probation, or give them probation instead of sending them to prison. Those are called departures. And there has to be a substantial and compelling reason for a judge to do that. In this case, the state has filed notice of seeking a finding of aggravated factors. those aggravated factors, if they're proven beyond a reasonable doubt, would permit the judge to sentence Derek Chauvin beyond what the presumptive prison sentence is. So if there's a conviction, and if they show that, I think, for example, one of them was George Floyd was particularly vulnerable, or if they also show that Derek Chauvin was in a position of authority, or if they show that the crime happened in front of minors, that would permit Judge Cahill to sentence Derek Chauvin above and beyond what his presumed sentence would be. So I think that's it in terms of kind of next steps in what we're going to be seeing beginning on Monday. I can turn it over to Josh, or if there's anything.
Actually, Nick, before you get to that, could you just talk a little bit about what happens if there's convictions on multiple offenses? What happens at sentencing there?
Yeah, so, and I'll probably loop you in here too. My understanding is that they would enter a conviction and sentence on the highest charge. Typically, when there are multiple convictions coming from a single behavioral incident, they don't necessarily enter the conviction for those or impose multiple punishments for that single behavioral incident, even though multiple charges arose from that. Josh, I think there might be some interplay between if it's a lesser included or if it's its own separate thing. But my understanding is, say he's convicted of second degree murder and third degree murder, the conviction would only be entered for second degree and sentenced on second degree. But if I'm wrong, I would love to. Yeah,
I just think bottom line is the state can bring basically multiple theories about how someone has violated the law during the same course of conduct, basically arguing that there are multiple criminal statutes that this person's conduct violated. For example, second degree unintentional murder and third degree unintentional murder. But if they are convicted, there's still only one penalty for the most severe. And as we talked about a couple weeks ago, both the second and third degree unintentional murder charges actually have the exact same presumed sentence under the guidelines.
Exactly. Yep. Thanks, Josh. Great points.
All right. So from there, we're just going to talk a little bit about what we might expect to see in terms of the arguments that the two sides are going to be making. And then
Josh, before you jump in here, there was a quick question thrown in to the chat. I don't know, Mica, if you want to raise it out loud and kind of see what Josh and Nick have to say.
Yeah, so someone said that they were surprised, Nick, to hear that you thought Chauvin will testify, thinking that that might be a little too risky. Can you comment on that?
Yeah, really good question. And I'll caveat with saying, you never know, and I don't know. I think in a case where someone needs to explain what they were thinking, what their mindset was, typically that can require the person to get up there and explain themselves. Now, there can certainly be arguments made about, well, we heard from this expert that he had been trained in that method. We heard from this doctor that X was happening. But I think a jury, even though they're not supposed to really to have it matter, I think a jury will want to hear from Derek Chauvin, to hear what were you thinking? Why were you doing what you were doing? Other folks can comment about sort of objectively what may or may not have been an appropriate use of force. But Derek Chauvin would really be the best person to explain his own mindset in that scenario. Josh, I don't know if you agree or disagree or.
Yeah.
He'll certainly get riddled on cross-examination. I will say that. It won't be an easy bit of testifying if he does take the stand. Absolutely.
We're going to talk here in a minute about one of the strategies that I think the defense will rely on, which is an affirmative defense, that the use of force was authorized. And we'll talk a little bit about what that means. But as it relates to this question, it's, I guess, important to point out that it is an objective test. So whether or not his use of force was authorized actually doesn't depend on his subjective mindset. So theoretically, then maybe he wouldn't have to testify because it doesn't matter what was in his mind, as long as what he did fits within the framework of the authorized force that we'll talk about here in a minute. I don't mean to be burying the lead I'm just trying to answer this question without spiraling into that rabbit hole just yet. So that might be a reason that he doesn't testify, but I do think Nick's point is really important, that, you know, what the defense is up against is this video that absolutely shocked the entire world, and that almost everybody looked at it and is like, how could that possibly be an appropriate thing for one of our law enforcement officers to do to anyone? And up against that hill, I do think there's a really sort of human thing that the jurors will be feeling, which is that they, you know, if he's got an explanation, I'm sure they'd like to hear it. And they'll be instructed not to hold that against him if he doesn't testify. But, you know, it's one thing to instruct a jury to do something, but there's no controlling what they do once they go back in the deliberation room. And so if the defense team thinks that Derek Chauvin would present well on the stand, I think they would be thinking long and hard about having him testify for sure. But it really is a risk reward thing. And if they think he won't do well, you know, and you know, his nerves are shot, or he just doesn't present well, or, you know, he's, you know, not very articulate, or he gets confused or whatever, maybe that would be a reason not to have him testify. I will say police officers do get training in how to testify, because, you know, when they're not the criminal, when we're not the defendant in a case, like, usually their role is to be a witness. So, you know, I don't know much about Derek Chauvin in particular in that regard, but I would expect that, you know, at least at some point in the past, he's either testified in, you know, as a state's witness in court cases, or at the very least has had a bunch of training on it.
Thank you, Josh and Nick. And again, for all people watching, if you do have a question, you can put it in the chat or in the Q&A, and we will get that answered as well. So we will continue on.
Okay, so in terms of the arguments, the first three slides I have here, these are just holdovers from the last session. These are just basically the elements of the three charges that Derek Chauvin is facing. And these are sort of the roadmap for what the state is going to be arguing about, because these are the things that the state has to prove beyond a reasonable doubt. They've got to have the jury answer in the affirmative when asked on the jury instructions, yes or no, did Derek Chauvin's actions cause the death of George Floyd? And then, and so, you know, so fundamentally, this is sort of an outline for what the state's argument is going to be. So for the second degree unintentional murder, they're going to argue that that Chauvin's actions were the cause of Floyd's death, and that happened while Chauvin was committing or attempting to commit a felony offense of assault in the third degree. So then that means that they're going to have to prove assault in the third degree, which means they're going to have to prove that Chauvin was committing an intentional act, that his act of kneeling on George Floyd for that substantial period of time was something that he was doing intentionally. And then that caused significant bodily harm, which that ultimately led to Floyd's death. So that's sort of just kind of the fundamental sort of outline of what the state is going to be arguing. It's pretty similar for the other charges. Again, the causation element is exactly the same. The way that they sort of form the nature of the intentional act is a little bit different for third degree unintentional murder. So instead of Chauvin committing another felony offense for the third degree unintentional murder, he just needs to be doing something that the jury feels was imminently dangerous to other people, including Floyd, and that he was doing that with a depraved mind, meaning he was doing it without regard for that danger to Floyd. And if the jury sort of answers those questions in the affirmative, yes, the state proved them beyond a reasonable doubt, then that's how the state would prove their case for third degree unintentional murder. And it basically the same thing for manslaughter, but again, with a slightly different intent standard of gross negligence. But where I think the actual arguments are going to be are around two things. In terms of the elements, I think there's going to be likely going to be an argument about whether Chauvin's actions actually caused Floyd's death. And I'm saying that because that's something that the defense already raised in their pretrial motions to dismiss for lack of probable cause. And so the argument is, and you may start by thinking, okay, well, the Hennepin County Medical Examiner already put a finding here that the manner of death is homicide, right? And that means that the medical experts looked at it and said that that Floyd died because of the act of another human person, because of the actions of Chauvin. That's what homicide means. But for the purposes of the criminal trial, the medical examiner's finding, which is sort of an administrative thing that has other purposes beyond just being evidence in a criminal trial, doesn't by itself equate to proof beyond a reasonable doubt that the causation element of the criminal charge was found. That's something really that it's only the jury's purview to make that decision. But there is a ton of case law that sort of examines what it means for one action to be the cause of another action. And one of the things that I think will be interesting to see if the defense does, the defense could kind of go at this argument a couple ways. The one thing they might just try to argue just flat out that it is a muddy enough question about, they're definitely going to point to, the drugs in Floyd's system. They're going to point to his prior health problems. They may just flat out argue that it is muddy enough and hard enough to determine what the actual cause was under these circumstances, that the state hasn't met their burden of proving causation beyond a reasonable doubt. The other thing, though, that they could argue beyond just sort of saying the state hasn't got, the state can't articulate causation clearly enough here, is they could try to argue that the intoxication, George Floyd's intoxication, his prior pre-existing medical condition, that those things actually led to superseding causes or other causes that sort of undermine anything that Chauvin had done to cause the death. And so we've got this sort of tension here between a substantial causal factor. So that's the language that the jury instructions, the form jury instructions use in defining what the state has to prove in terms of causation. So the state doesn't actually have to prove that the defendant, that Chauvin's actions were the only cause of Floyd's death, but they have to be a substantial causal factor, and it can be a substantial causal factor along with other circumstances. That's still okay for the state. But if it rises to the level of being a superseding cause, something else that basically changes the natural flow of the circumstance, then that could be something that the defense could argue actually does undermine the causation. And it'll be interesting to see. I don't yet know exactly how that evidence is going to come in and how the defense team is going to try to argue that. But that's something at the very least to watch for, and also could lead to some interesting arguments as we get closer to the close of the trial about what exactly the jury instructions themselves are going to look like. Because that'll be where sort of the judge is explaining this sort of messy case law to the jury and trying to explain to them how they should be applying these concepts like substantial causal factor and superseding cause to the evidence that they've heard. The other big argument that I think that we're going to have is going to be around whether or not there's this affirmative defense of authorized use of force. And so this sort of area of the law actually goes back to a US Supreme Court case called Graham versus Connor. That's about 30 years old now. But it's also been codified under Minnesota statute. And basically it's used in any circumstance really where somebody is arguing in court that a police officer used excessive force one way or the other. So Graham versus Connor itself is actually a civil case for damages because of a Fourth Amendment violation. But the standard that the court used has then been adopted and sort of applied to all situations where the question before the court or the jury has to do with whether the officer's use of force was appropriate or not. And the basic test, the basic sort of outline of the defense is that it is a defense if the officer, so if Derek Chauvin's use of force is justified, if it was objectively reasonable given the totality of the circumstances. So I said before, it's actually not a subjective test, meaning it's not a question of what Chauvin was actually thinking. It's a question of sort of looked at from the objective point of view of outside of the officer's personal belief. Are we prepared to say that the actions were reasonable given the totality of the circumstances? And then the real sort of kick, because that's actually pretty similar to just standard self-defense that anyone would be able to raise. But the real kick here is that from Graham versus Connor, and that's been codified under Minnesota statute, is that reasonableness determination has to be viewed from the perspective of a trained police officer on the scene. And the court in Graham versus Connor specifically sort of warned against using like 20/20 vision or hindsight. So there's deference sort of baked in here to the split-second decisions that peace officers and police officers have to make. And there's also sort of deference to their training. And that's what is going to sort of open the door for the defense here in this case to call, police trainer witnesses who will talk about, all of the things that they train police officers to be afraid of, basically. I mean, frankly, to be on the lookout for all of these things that they're sort of trained to use to justify force. And then sort of argue that under the circumstances of what was happening here, the amount of force that he used was actually reasonable. So if I'm sort of thinking how the defense might frame that, they're going to say that he was acting erratically, he was resisting, he was refusing to get in the car. And so all of those were things that justified some use of force. And then the question is, well, is the amount of force used reasonable? And the defense is going to have to try to argue yes, which personally I think is a hard argument, but that's the argument that they're going to have to make. They'll probably say, that they're trained to hold people down. They may try to argue that Chauvin was actually being careful somehow. I know in some of their pretrial motions, they argued that the absence of any like bruising on Floyd's neck and back, the sort of evidence that Chauvin, despite what it looked like on the video, was actually being careful not to harm him. Again, I'm not endorsing these arguments. I'm just trying to sort of give everyone a preview of what I think the defense is sort of likely to argue. But the framework here is pretty clear that they're going to be trying to argue that the use of force was actually authorized under the circumstances, something that was consistent with Chauvin's training and was objectively reasonable within the framework of the training that officers get. All right, that's our sort of quick preview of the trial process and kind of the main argument points. I think we can open it up to questions now. Mica, do you have any lined up?
Yeah, awesome. So we do have a question. What is the timeline for an expected verdict, as in terms of dates? When can we expect to hear what those verdicts will be?
Well, we know just from our caseloads that the court isn't expecting things to get back to normal until the first week of May. So whether it will actually go that long, I don't know. I mean, we saw that they blocked out 3 full weeks for voir dire, and despite having some pretty significant legal arguments that had to be made in the first couple of days of that they weren't even planning to do, they still got through that with a few days to spare. So, it could be earlier than that, but, I think it's a safe bet that it's going to be most of April. Would you agree, Nick?
I would. Yep. I think they're estimating, about 4 weeks. That would take them through that, and then it'll really just depend on how long the jury needs, and that really just depends on the jurors. It could, take a few days, could go anywhere from a week, potentially onward from there. But they've been moving along. Judge Cahill is doing his best to keep a very tight schedule, and he doesn't want this to go on any further. So as much as he can control, he'll try to keep things moving, and then it'll just be in the hands of the jury.
Okay. Thank you. We have another question. It seems that the personal jurors who were sympathetic to police were routinely allowed, and anyone expressing a positive attitude towards BLM or similar issues were not. Do you agree? And why was this allowed?
I will admit that I have not been able to watch jury selection super closely. Nick, do you have any thoughts on that?
Yeah, I would say from my personal opinion, watching, I am and was a little skeptical at some of the jurors I think the state let come on. There were a few that I thought they may have chosen or opted to use a peremptory strike to say, hey, this person seems fairly sympathetic to the police, and just as the questioner is pointing out, maybe not so positive towards BLM or racial justice. So, in terms of that, I'm sure the state, they must have had their reasons. But from the outside, it looks like that was absolutely the case. In terms of saying, how could this be okay? It's really a matter of pressing them for cause, right? Similar to Josh, I didn't have a chance to watch and review every juror, but there were a few where the attorneys really could push them to say, I really can't trust this, or I really can't trust that. So whether I like it or not, I think there were some instances where for cause was big picture appropriate. But I do have some concerns about a few of the folks the state let on. Again, it would be interesting to sort of hear their discussions about why they let some of the folks stay on that stayed on.
Yeah, I guess I would add that it can be pretty tricky sometimes to actually get someone struck for cause. Yep. Especially if the juror is kind of savvy, and wants to be on the panel. Because if they say sort of the magic words of, despite what I thought coming into this, I will be open to listening to the evidence, and I will be impartial, and I can be impartial. I can set aside those preformed opinions and follow the instruction, then that gives permission for the judge to deny the for cause strike. You could still try to argue that they're lying, but it's a lot harder if you're trying to argue that somebody is lying about their ability to be impartial. And then from the point of view of the state, they do have less opportunities to issue for cause strikes. So it may be that they were not super thrilled with this juror, but felt like they needed to keep some of those in their pocket in case someone was worse down the line. This trial did something sort of odd with how they ran voir dire, which is that they asked the attorneys to issue strikes as they went while they were individually questioning the jurors. And in most trials, you don't get the opportunity to individually question the jurors. You question them all at once. But then that also means that you issue all of your strikes at once. And so like what we'll typically do is basically sort of rank the jurors in terms of, how high of a priority are we, do we think we need to use a strike on this person? And then you actually sort of trade back and forth. So the defense will do a couple, the state will do one, the defense will do a couple. And then, basically you whittle out the jurors that you don't want kind of in the order of how prejudicial you think that they will be. And the state didn't really have the opportunity to do that just because of the way that they structured voir dire here. So I'm speculating here, but it may be that they agree with Nick's concerns and to the questioner, your concerns about this potential juror, but they felt like they needed to keep that strike in hand.
Yeah, great points. And the one thing I would add too is that the attorneys did have those questionnaires that we're not privy to, right? So they may have known, hey, this other juror is coming up next, and based on their answers, we're a little more concerned about them. So maybe we do want to save that strike. So that is another possibility too.
Did anybody know, did either party use all of their strikes?
I don't know. I thought the defense did, and then they had the additional ones, but I could be mistaken about that. So I guess if any of the, Mica, if you know, or if any of the viewers know. Okay, Gail saying neither party.
They used all their strikes, or neither party used all their strikes, rather.
They didn't, okay.
Great, thanks, Gail.
Okay, next question. And this, I think, Nick, goes back to what you were talking about with a jury having to be unanimous. And if not, it will be declared a mistrial, and then the state can choose whether or not to retry. Is there a limit for how many times a case can be retried? Can this potentially go on like in an infinite loop, or like is there a specific way, say this is retried, that the next, if a jury is again can't find a unanimous decision, what's the step after that?
Yeah, as far as I'm aware, the state can keep doing it. And there was, I think it's called, Josh, you probably heard it. It's after there's an NPR about a man whose last name was Flowers, and he had been tried, I think, like 6 different times, and it was Louisiana, somewhere down south, I want to say. And there were just so many problems with what happened to this person and what happened with every trial. But the state just kept choosing to retry and retry and retry and retry. And it was really up to the discretion of the prosecutor to say, hey, yep, for whatever reason, we are going to keep doing this. So in some cases, the state might look at it and say, hey, you know what, this just isn't worth it, or we don't think we're going to be able to prove our case if they didn't agree with us based on what we put on here. But I think the state would have the discretion to sort of just keep going to whatever extent they felt they could. Josh, I don't know if that.
Yep, no, I think that's right.
Okay, great, thank you. And then you had mentioned that the motions need to be sort of used in this court, or else they, you sort of a use it or lose it type thing if it's going to go to the Court of Appeals. What other motions can we potentially expect either side to use, so they can reserve that for the Court of Appeals if need be?
The main thing we'll see with that is protecting the record with respect to what evidence comes in. So you'll see objections, a hearsay objection, for example, even where you can kind of anticipate what the other side's response to that is going to be, but you might make it anyway just to preserve that. And then the other big one I would say is any arguments about what the jury instructions are going to be and what the language. I mentioned before what exactly is the language about causation going to be to the jury, those types of things.
And Josh, so we have standard jury instructions and we have statutes. Do those have to guide it, or does the judge have some discretion to add or tweak things?
Yeah, so that's a good point. So the court relies really heavily on what we call the jigs, the jury instruction guides. And this is, basically a document published by Thomson Reuters, by Westlaw, that has, sort of a committee has gone through and created model jury instructions for courts to use. And judges like to sort of stick to those because they're sort of an independent justification for using them, and the courts of appeals have looked at them, and when there is a problem with them that the Court of Appeals identifies, then the jigs get updated to reflect that. And so it's sort of a good, safe way to go. But the jigs don't always anticipate every wrinkle that can come up in the trial. And so, specifically, if there, and I don't know if there will, but if they do get into sort of a big argument about sort of what are the parameters of a superseding cause in the context of somebody who has ingested, illegal narcotics right before being, put in a stressful, painful situation at the hands of a cop. The judge might actually make sort of legal findings about how the jury should apply the analysis of superseding causation in that context, and that could result in basically the parties and the judges sort of collaboratively drafting and arguing about, and ultimately the judge ruling on what exactly the language should be. So the jigs are kind of a starting point, but it's pretty common for there to be modifications that the parties argue over when you're actually applying the jigs to the specific facts that have been introduced in the evidence at trial. That makes sense? Nick, did I miss something?
No, I think that's absolutely right. Yep. And another reason it's important too is because the jury, when they make their verdict, the form that they get, with some exception, typically just says it has a place where they can mark guilty or not guilty. There's not sort of a bunch of blank lines to fill in their reasoning, right? So you want the instruction to be as precise as they can be to say, here's exactly what they considered. And they agreed or didn't agree that it met that portion. So that, just one more reason why you want to be as precise as possible, using the guidance of the jigs, using the guidance of the statute, and making sort of any of those tweaks to it as the parties would try to argue.
It looks like we have a question. What did you think of the judge's meltdown the other day? I'm not really sure what that's, I wasn't able to watch. I'm worried that he may be leaning towards the defense.
And Gail, I'm assuming you're referencing, I think it was last Friday, when the state had asked for the defense to sort of be a little more precise in their statements regarding the city of Minneapolis discussing the settlement. So if that's correct, I think I did have a chance to watch that. I would say this, as a defense attorney, it was a little surprising and I think selfishly a little pleasing to see a judge sort of pushing back on a prosecutor. Obviously we're in this juxtaposition of, we obviously have strong feelings and opinions about what MPD did to George Floyd, but we are also defense attorneys, and we sort of have our experience is sort of that of a defense attorney. So I think the judge was telling the state, hey, you have this team of lawyers. Every attorney is an officer of the court, so we are presuming that the attorneys are going to be putting forth truthful statements and not, at least not intentionally, making any incorrect statements. So I think, as an outsider watching, I think Judge Cahill felt the state was being a bit nitpicky about asking for an affidavit as to what the exact language used by the Minneapolis city attorney was. And I think Judge Cahill felt that it was sort of turning into kind of just a finger pointing argument to say, Judge, they didn't do this, they should have done it this way. So, I don't know if that indicates he's leaning towards the defense. I think he was leaning towards telling the attorneys, hey, let's be grown up about this, and let's not sort of get into that level of kind of slinging mud about something that isn't necessarily a big deal. So that's my perspective. I don't know if that signals he's leaning towards the defense. I think he wanted the attorneys to, in the process of fighting in an adversarial process, to keep it focused on what is really, really important. Maybe not necessarily said, what the Minneapolis city attorney said. So lots of attorneys, poor defense only has two. Sorry, I'm just reading your follow-up comment here. I think it was just talking about acknowledging that the state has a team of attorneys out back at the office getting out that subpoena. I think if anything, I would chalk it up to housekeeping. I don't think it would actually indicate how he leans towards the legal arguments being made. And I would note, the defense probably has a whole field of attorneys too that just don't come to court. I really doubt that it's just Eric Nelson by himself doing everything, which wasn't mentioned. So definitely, I think it was sort of a display of optics, and I think the judge trying to keep the attorneys reined in to some extent about what they're actually arguing about.
Okay, thank you. We have a couple of minutes left. There is one last question I think is be pretty important to sort of sum up as quickly as possible. So why is information about the 2019 arrest of George Floyd being included in the trial? And do either of you think that information about Chauvin's disciplinary record, will that also be included? For example, I don't remember how many years ago it was, he was involved with the shooting of a Native American man named Leroy Martinez. So will those kinds of facts or anything be brought into this trial, and why?
Let's see. I know some of those were issues that were being brought up in the MOLIMs, the motions in limine. I don't, had the judge actually decided any of those? I kind of got the sense that a lot of them they were going to wait and decide on as the state or the defense tries to introduce them. Did you notice, Nick?
Yeah, partially. My understanding was for the 2019 incident, prior incident with George Floyd, specifically statements that the observations that the paramedic who treated him could come in, and that George Floyd had consumed drugs could come in, basically as going towards what Judge Cahill is saying is going towards cause of death, because cause is obviously going to be bickered about. So the defense is going to use that to say George Floyd previously consumed drugs in a very similar situation, and the effect it had on his body was that it sent his heart rate, sky high, to the point where the paramedics believed that he was at extreme risk for stroke or heart attack. I think that exact language Judge Cahill said could not come in, but the paramedic could and potentially will come in and testify about what they observed in George Floyd's medical behavior as a result of the drugs, and why, if at all, it was concerning to them. So talking about, why did it concern you that his heart rate was so high, or what does that mean? But the other, George Floyd, the basic act of, any resistive actions or, sort of crying out for help, where the defense was trying to say, hey, this is a habit and he's a faker. Judge Cahill said that can't come in, that portion won't be allowed. In terms of Derek Chauvin's prior, disciplinary actions or the shooting involvement, I'm not sure. Josh, I'm in the same boat. I don't know what Judge Cahill decided on that as of yet.
We might have to shelve that one and do a little research and bring it up at our next session.
Yeah, that sounds
maybe a
good.
little bit more timely. Well, yeah.
Yeah, but great question.
Okay, well, thank you both very much, and thank you for everyone who attended. I do believe this video is going to be on our website. So if you want to share this or just revisit some of the questions, they'll be on there. And then we will have a forum sometime next week as well. So feel free to tune into that. And thank you all, and have a wonderful weekend. Or I suppose it's Wednesday. It feels like Friday for me.
Thanks, everybody. And Gail, thank you for all your great questions as well.
Thanks, everyone.